parties on the issue of public interest. We have also considered and reflected on the analysis and evaluation by the trial court on contestations relating to public interest. At paragraphs 2, 3, 5 of each judgment, the learned judges suggest that if the IEBC placed material before the court from which it could make the permissible inference that the scenario warned against is more likely to happen, the court may not have granted the orders. The statement by the learned judges is a correct exposition of law, taking into account that the orders of certiorari, prohibition, and mandamus are discretionary orders that may or may not be granted by the court. From the Honorable Attorney General's submissions as well as from the first respondent's reply, the contestations relating to public interest revolve on time constraints to conduct the general and presidential elections on 8 August 2017. We have re-evaluated the evidence on record and asked ourselves what material was before the trial court in relation to time constraints. The trial court at paragraph 2, 3, 5 of its judgment observes that the IEBC is expected to have the expertise to generate operational programs, including timelines, for conducting the presidential elections. The trial court has timelines to be an operational issue and that IEBC caused upon itself the potential difficulties it finds itself in. In our view, the High Court erred in fact and law in considering timelines for the conduct of election to be an operational issue to be generated by the IEBC. The timelines for procurement processes is statutorily regulated through regulations made under the Public Procurement and Disposal Act 2005. The procuring entity is simply implementing the timelines as statutorily provided. The relevant regulations on timelines include regulations 36, 40, 46, 54, 5 of the 2005 Procurement Act and Section 86 of the Public Procurement and Asset Disposal Act. At this juncture, it is important to note that the regulations in force are the Public Procurement and Disposal Regulations of 2006 by Legal Notice number 174, Kenya Cassette Supplement number 92, dated 29th December 2006. These regulations are still in force pursuant to Section 24 of the Interpretation and General Provisions Act. The 2006 regulations also remain in force pursuant to Section 182(2) of the Public Procurement and Asset Disposal Act of 2015. The relevant regulations in 2004 Procurement Act and Section 80 of the 2015 Procurement Act are as follows, and we have set them out. A cursory glance and the relevant regulations in the 2005 Procurement Act and Section 80 of the 2015 Procurement Act are as follows, and I will read. Regulation 36. For purposes of Section 71C of the Act, the minimum period of time between advertisement and the deadline for submission of international tenders shall be 30 days. Regulation 14. The minimum time for the preparation of tenders for the purposes of Section 55(1) of the Act shall be a period of 21 days. Regulation 46. A procuring entity shall, for purposes of Section 66(6) of the Act, evaluate the tenders within a period of 30 days after the opening of the tender. Regulation 55(2). The notice inviting expressions of interest prepared by the procurement entity pursuant to Section 78 of the Act shall give a minimum period of 14 days for tenderers to submit their expressions of interest. Regulation 54(5). The minimum time for the preparation of tenders for the purpose of Section 73 of the Act shall be a period of 14 days. Section 86 of the PPDA Act 2015, the evaluation shall be carried out within a maximum period of 30 days. A cursory glance and simple arithmetic calculation of the timelines provided for in the procurement regulations demonstrate that if the presidential election is to be held on 8th August 2017 and backward calculations of timelines is done, it is manifest that a procurement method other than direct procurement will not lead to award of tender before the constitutionally ordained date for the conduct of presidential elections. Each procurement entity is mandatorily required to adhere to the timelines for processing of bid documents as stipulated in the regulations. A court is presumed not only to know all laws but to apply all laws relevant to the case before it. In this case R versus Shepherd 2002, it was stated judges are presumed to know the law with which they work day in and day out. This is sound presumption applicable in Kenya. We have perused the record of appeal and note that the trial court did not address its mind to the procurement timelines in their regulations. The replying affidavit of Mr. Ezra Chiroba, dated 27th June 2017, at paragraph 6 thereof, the appellant brought to the attention of the High Court that an expert had advised that there was very limited time available to procure the election materials. It was stated that the expert's advice was to use direct procurement. In paragraph 5 of his affidavit, a timetable of key activities and timelines was brought to the attention of the High Court. It is our considered view that had the trial court addressed its mind to the timelines as stipulated in Regulations 3640, 4654-5 of the Procurement Act 2005 and Section 86 of the Public Procurement and Assets Disposal Act 2015, the learned judges would have appreciated that indeed there was no sufficient time to restart the process for procurement of election materials. To this extent, the learned judges erred in their finding that there was sufficient time to start the procurement process. Notwithstanding the foregoing, we must emphasize that IEBC and all state organs are bound by the rules, the values and the principles enunciated, among others, in Articles 10, 2001, 201 to 271 of the Constitution. The values and the principles of accountability, transparency, free and fair elections can never be sacrificed at the altar of time constraint. It is not worth to hold a non-transparent and flawed general election at whatever cost, simply because time is a constraint. Notwithstanding time constraints, IEBC and all procurement entities must at all times remain accountable and transparent and in their operations, and must adhere to the values in Articles 10, 201, 227 and 232 of the Constitution as incorporated in Section 3 of the Public Procurement and Asset Disposal Act. We reiterate and endorse the statement by the trial court at paragraphs 153 of its judgment that in the conduct of elections, IEBC must adhere to the standards set in Articles 81 and 86 of the Constitution and conduct free and fair elections that is inter alia accountable and transparent. We have taken into account some of the submissions made by the Honorable Attorney General, Learned Counsel, Mr. Paul Mwangi, and the seventh respondent. Part of their oral submissions termed scaremongering, brainwashing, and the tripping of the first blood was speculative and imaginary, and we find it unnecessary to delve into such hypothetical and conjectural issues. we confine ourselves to the finding that timelines for procurement processes are regulated by law, and it is to this regulation
by hypothetical and conceptual issues